New York recently enacted 2 laws impacting employee rights with respect to claims of discrimination, harassment, and retaliation. The first modifies existing law regarding non-disclosure and non-disparagement terms in certain agreements. And the second extends the statute of limitations for discrimination and retaliation claims.
First, New York amended its law on non-disclosure and non-disparagement provisions in certain agreements. These amendments apply to agreements entered into on or after November 17, 2023. New York General Obligations Law, Section 5336, only permits confidentiality and non-disclosure provisions in certain settlement agreements if confidentiality is the complainant's preference, and this preference is documented in a separate agreement. Previously, this requirement only applied to agreements resolving claims of discrimination. Now, this requirement also applies to agreements resolving claims of harassment and retaliation. The amended law also provides that employees must be given up to 21 days to consider the separate agreement setting forth their preference for confidentiality, but can sign in less than 21 days if they choose. Previously, this 21-day review period could not be waived. However, employers should note that under the New York Civil Practice Law and Rules, settlement agreements resolving claims of discrimination that have been filed in New York State Court continue to require the full 21-day review period. New York General Obligations Law, Section 5336, also requires that if an agreement could prevent the disclosure of factual information related to any future claim of discrimination, such as provisions contained in a confidentiality agreement, such agreement must notify employees of their right to speak with law enforcement, the Equal Employment Opportunity Commission, state or local human rights agencies, and the employee's attorney. The recent amendment added the Attorney General to this list, and made it clear the provision also applies to agreements with independent contractors. Employers should also take note of the new limitations on agreements signed in connection with discrimination, harassment, and retaliation claims. Under the amended law, the release of any such claim is unenforceable if it requires the complainant to pay liquidated damages or forfeit consideration for violating a non-disclosure or non-disparagement clause, or if it requires an affirmative statement by the employee that the employee was not in fact subject to unlawful discrimination, including discriminatory harassment or retaliation. Employers should review their agreements to see if any changes should be made to address the recent amendments. There is also still some ambiguity about when the law's provisions apply. We recommend that employers involve counsel whenever entering into an agreement with employees where there have been any allegations of discrimination, harassment, or retaliation.
Second, New York has extended the statute of limitations for discrimination and retaliation claims brought under the New York State Human Rights Law from 1 year to 3 years. Currently, New York has a 3-year statute of limitations period only for claims involving sexual harassment in employment, and a 1-year limitations period for all other types of claims brought under the New York State Human Rights Law, such as claims of age or race discrimination. Effective February 15, 2024, the 3-year statute of limitations will apply to all claims brought under the New York State Human Rights Law. If you have any questions about these new laws or any other employment questions, please reach out to a member of our team.